Today I'm going to discuss with you the First Offenders Act in Georgia. I have many questions regarding this specific topic, so I felt that this video would be helpful in determining whether or not your particular crime that you're charged with is eligible for first offender treatment. In order to be eligible for first offender treatment, some of the basic eligibility requirements are as follows. First of all, you've never been convicted of a felony in the state of Georgia or in any other state. Secondly, your crime must be one of those offenses that can be eligible under the First Offenders Act. And those crimes would not include driving under the influence, any aggravated violent offense against a law minor, or sexual related offense against any child. Those are some of the offenses that are not eligible, primarily the main ones that are not eligible for first offender treatment. If you are charged with any other type of offense, whether they be felony or misdemeanor offense, those can be eligible for first offender treatment. You are eligible for first offender treatment only on one case. You are not eligible for first offender treatment multiple times. So once you've used first offender treatment on a case, you will not be eligible to use that at any other point in time. What first offender treatment is it allows the charge to be served under a probationary period or a time frame, and then once that time frame is completed, then you can at that time have this charge dismissed or removed from your conviction record. What that primarily means in layman's terms is that while serving this sentence that you receive under the First Offenders Act, you will not per se be convicted of this particular offense. That doesn't mean to say that you cannot eventually be convicted of this offense. One way that you would be convicted would be that if you were to violate the terms and conditions of any probation that you receive pursuant to the sentencing under the First Offenders Act. If you were to violate the terms and conditions of your probation, you could be facing not only the conviction for this particular offense and any ramifications that that conviction would result in, but also you could be sentenced up to the maximum that is allowed by law for the charges in which you have received first offender treatment on. In essence, if you decide that you want to have first offender treatment, some of the benefits would be that once you completed your probationary period, then this charge could technically be removed from your record. When I say removed from your record, I don't necessarily mean that it would be restricted or expunged or removed completely from your record, but what I do mean by that is that it would not show up as a conviction and you would be shown as discharged of this particular offense. You would not lose any of this rights that you would lose if you were a convicted felon, such as the right to vote, serve on jury duties, or anything of that nature, while serving the sentence. However, while under first offenders, you would, however, be prohibited from carrying a firearm pursuant to Georgia law. Once you completed your sentence, you would be eligible again for carrying a firearm pursuant to the present Georgia law carrying gun permit laws. In order to receive the first offender treatment, the process is fairly simple. First, you would determine whether or not you're eligible for first offenders. Secondly, your attorney would then require or ask the judge to sentence you under first offenders. Receiving a first offender sentence is 100% in the discretion of the judge. Many times prosecutors do not object, and more likely than not, the judge will sentence you if you seek this specific privilege. Once you're sentenced by the judge, then what will happen at that point in time is it will show on your criminal history that you have been sentenced under the First Offenders Act. Once you've completed that program or the probationary period, then upon completion, your probation officer will recommend to the judge that you be discharged of this particular offense, at which point in time this record will then be eligible to come off of your GCIC. This does not mean that it will not be eligible for being seen by law enforcement officers or the court system. When I say the court system, I mean district attorney's office, judges, and things of that nature. However, this charge can be seen by employers if your employer seeks to look up your record by using third parties such as agencies that do criminal histories. In the event that this still shows on your criminal history, what you'll need to do is go through the process of sealing your record, and that's explained to you in another video. Now, there is a particular type of first offenders which is called conditional discharge. And conditional discharge is available for a specific type of minor in possession of alcohol and is also available for drug offenses. The eligibility requirements and conditional discharge are explained to you further in another video that we will be doing called Conditional Discharge. If you have any further questions regarding the First Offenders Act or would like to ask specifically if your particular crime is eligible for first offenders, please feel free to schedule a consultation with me in my office. I have offices located in Cartersville and Kennesaw. We serve Cobb County, Bartow County, Paulding County, Cherokee County, and the Northwest Metro area of Georgia. Our number is 404-997-8470, and you can visit us at our website, which is cbcriminallaw.com. Thank you.